Clock cutoff. So y'all, everybody that wants to speak, please, as y'all are doing, you go ahead and sign in. I'll preemptively say that we'll get to as many of you guys as we can, but it may not be everyone. That will kind of depend on the flow with questions from the committee. So, Senator, if it's just you and I, then maybe we'll get the public testimony quicker. Can we, Mike, can we move that sign-up sheet right over to the corner of that table, and we can have the line there? We'll have Representative Bonner come down front so we can maximize our time. And as soon as we hit 5 o'clock, we'll start. Just to give you guys an idea of flow of what we're going to do today, this is the a Senate subcommittee of the Judiciary Committee. So this House Bill 267 has been assigned to the Judiciary Committee. Chairman Strickland has formed the subcommittee, which is made up of myself, Senator Parent, Senator Hatchett, and Senator Watson. And we will ask Representative Bonner to present his bill. I'll allow the committee to ask any questions. We'll then take public testimony to the extent that we have time, and then we will take action. This will then go up to full committee, and then there will be an additional hearing process in full committee as well. So hopefully that gives you just level sets expectations for what we're going to do today. And Representative, it is 5 o'clock, so we will go ahead and start. Thank you for being here. Talk us through this is a House sub that you have. This is not a sub that's changed as this bill passed the House. Is that correct?
That's correct, sir.
Okay. Why don't you tell us about your bill, and then I will allow the committee to ask questions.
Okay, great.
Thank you.
Well, thank you, Senator, member of the committee. Thank you for the opportunity. First of all, let me just say, as the father of a female athlete, I appreciate what the action that the Senate has taken. I certainly followed the study committee that the Senate held over the interim and watched that closely, and certainly learned a lot from it. I've personally have been working this issue since 2021. Came in office in 2017 and started working this issue in 21. And so I think the fact that both chambers are taking action certainly underscores the importance of this issue and how much the state of Georgia is concerned about it. So I want to thank the Senate for that. And I know that you've had some very robust discussion in the Senate. And so what I'd like to do, Mr. Chairman, if it's okay, just kind of give some of the highlights, the high level of the bill, and then stand available for any questions. And we are working off of LC 492300S. That's the House substitute, and this is the bill as passed by the House. House Bill 267 is the Riley-Gaines Act, and starting in Section 2.2-1, it applies to our K through 12 schools. We go in and define terms and establish protections for female spaces during athletic events. That includes restrooms, locker rooms, changing areas, and shower rooms. It also addresses overnight trips in conjunction with an athletic event on lines 83 through 92. Now, these areas will be required to be designated for use for male and female athletes. And if there's a student that does not feel comfortable in either one of those, a reasonable accommodation is required. This accommodation shall include, but it's not limited to, allowing access to a single occupancy restroom or a changing area. Now, provisions are made, and this was a part of what the substitute includes. Provisions were made for authorized custodial, maintenance, inspection, medical aid, parents, legal guardians, and then the last two we added were authorized coaches and trainers directly related to those athletic events. We wanted to make sure that we wouldn't jam up a coach or a trainer that came in to tape an ankle, those kinds of things. Lines 93 through 116 establish the recourse for violations of this bill. The Professional Standards Commission is authorized to investigate complaints and sanction individuals subject to their jurisdiction in the K through 12 schools. And then additionally, parents and legal guardians have a cause of action in the event their student is harmed under the provisions of this bill. Section 2-2 addresses our post-secondary institutions and includes all the same cause of action language that's in the first section. Section 3-1 addresses the protection of female athletics, the specific teams. Those teams are required to be designated as male, female, or co-ed. It allows the birth certificate to be relied on for the purposes of determining eligibility if the sex designated on that certificate was designated at or near the time of the participant's birth. We're mindful of the concern of visual inspections and address that in lines 262 to 267. Now, nothing in this bill prohibits males from practicing with female teams, but it does protect female roster spots and scholarships. This section also includes the cause of action in the event of harm. In Section 4-4 and the remainder of the bill, as addresses Georgia Code and cleans up Georgia Code, it replaces the word gender with the word sex, and that will allow for more detailed and accurate data being collected throughout all of those. That, Mr. Chairman, is the bill, and I'll be happy to answer any questions.
I've got a couple of quick questions, and then I'll recognize the other member of the committee for a couple of questions. How do you treat private schools in the bill?
So private schools are included. If a private, for instance, in the K through 12 arena, if a private school participates with public schools, they are under this jurisdiction. And then for any post-secondary institutions, those that are eligible for tuition equalization grants under Code Section 20-3-411 are subject as well.
Okay. Can you walk me through the work that you did in Section 4 and just give us let us know, I'm just kind of curious what all the areas are that we're touching here
Sure.
of the existing code.
Understand. So, for instance, Section 4-2, starting on line 329, that addresses just the general provisions in law and replaces that. We hit areas in Section 4-3, starting on line 337. Those definitions do not currently exist in code, so those are new definitions that are simply added to the list of defined terms. 5-1, starting on line 353, is related to our probate courts. And then we go into different sections regarding driver's license, organ donations, those types of things, crime reporting, those types of things that require very detailed and accurate data.
I know it's a number of things, but do you mind just going section by section?
Yes,
Do you have that?
Yes.
So
So I think I left off at
5-2 would be next.
Yeah, so 5-2, that is related to bias crime reporting, and we did, the original bill had a section that addressed the hate crimes bill. We deleted that, so the only change here is to address the standard, where we changed that legal standard from appears to an actual legal standard of a reasonable suspicion to believe. Then 5-3, starting on line 375, just addresses different portions of the education code, again, to make sure that instead of the word gender, the word sex appears. There's a number of issues. And then Section 5-4, starting on line 429, that is related to the organ donor card. 5-5 is related to licenses. 5-6 again is related to the department.
Driver's licenses, or what type of licenses in 5-5?
Those are.
It looks like driver's license. I see the organ.
It is
Yeah,
driver's
okay.
license. So as the same with 5-6, starting on 465.
Okay.
And then on 5-7, starting in 478, that's regarding pre-K programs. 5-8, starting on 497, that one is related to membership of designated entities, just to make sure that they're identified correctly. And then in 5-9, it just hits those code sections 504 through the remainder of the bill, wherever in the event that the word gender would appear, replaces with sex.
Okay. Great. Those are all the initial questions I had. Senator Parent, did you have any questions?
Yeah,
Are you on 8 or 9?
Yeah, I can put it on 8.
Okay.
Thank you.
Thank you, Mr. Chairman. Thank you so much, Representative. I do have a few questions for you. Starting with just a couple of sort of like operational issues I see that I want to get your take on. So the definitions of male and female on, first appearing on lines 32 and 35, and then other places throughout the bill, as well as the definition of sex on line 46 and line 147. I'm going to focus for a second on the definition of sex. It says, an individual's sex can be observed or clinically verified at or before birth. Are you aware that that's actually not medically accurate?
And say that again, Senator.
Are you aware that is not medically accurate? That you can't always verify someone's sex by observation or clinical verification at or before birth?
Is there, what circumstances is
Well,
that?
yeah, there's a intersex people is primarily what I'm talking about, and there are different chromosomal differences, and there can be like estrogen or testosterone androgen receptor issues that can also cause someone to sort of be intersex, where they cannot be they certainly cannot be observed or clinically verified at or before birth in terms of what sex they might be in terms of the definition you've got here, and moreover they oftentimes have they may be like XXY or X only one X, like X0, which is Turner syndrome. XXY is Klinefelter's syndrome. And the thing is that I've actually learned in the discussions around these bills, and Chairman Dolezal and I had a little bit of a similar conversation in committee about SB1, but I've learned that it's like, I think most studies show about 1.6% of the population has some intersex trait. Sometimes you don't know it until puberty. Sometimes you don't know it until you run into infertility problems or have some other sort of scan that may show that you've got like undescended testicles, or just there's a whole lots of different things that medically happen. And what I find striking about it is that, and I'm getting to a question, what I find striking about it is that the percentages that I'm seeing in studies, there are more intersex people than there are transgender people. And this bill is focused on transgender people. And it's sort of like we can't ignore, the whole bill is because of transgender people, but we can't ignore that there are actually more intersex people. So I guess I want to know, given that this is scientifically and medically inaccurate, how does your bill contemplate this large percentage of individuals that are not male or female the way you've defined them?
So the language, individual sex can, doesn't say that it must be. It says it can, or not shall. It says it can be observed. And as far as those that fall into that category of intersex, those are covered in the bill under the American with Disabilities Act provisions. So I think we've addressed that overall concern.
Thank you for that. I thought maybe that might be your response because I saw that was in the bill, and I figured out that may have been the origin of it. But are you aware that intersex individuals are not mentioned at all in the Federal Americans with Disabilities Act? It's really not a disability.
I don't know whether that's true or not.
Okay, I did spend the afternoon researching that. I would just suggest that that's really some stuff that should get cleaned up because it's just not. Other legislation, I think most recently out of Montana, has been struck down by sort of trying to premise an entire bill in this very same way on something that's just completely scientifically inaccurate. So I do think that we should take a look at that. I got a few more, if that's okay, Mr. Chairman. So in terms of the sports, I'm looking at line 259. you touched on this in your opening remarks, Representative Bonner. So I want to follow up on it for a second. So is the idea that a the student or family will provide a birth certificate to determine what sports team that student would be eligible for?
That's correct. That would certainly be a part of it. Again, the intent was to not line up a row of kids and visually inspect to see which team they were going to go on. And so that's why we included the additional provisions starting in line 262 that essentially they can utilize the birth certificate if for some reason it can't be determined by that, and then it would rely on some medical examinations that are typically, and I say typically in every situation I'm aware of, are a part of the process to participate in a sport, either at the K through 12 or at the collegiate level.
Okay, yeah, that is something I was curious about, because I know that, and I did just go on Georgia.gov, you don't need a birth certificate to register for school. But so you're saying you do need one to register for school sports?
I'm saying you can utilize that. I know, for instance, at our schools in Fayette, in order to participate in any sport, you have to go through a medical screening. So you've got to go through a series of medical checkpoints in order to be eligible for that. So if the school or the district wants to utilize birth certificates as a part of that process, there's nothing to preclude that from happening.
So essentially, from the statewide perspective, that's interesting about how Fayette does it, but from the statewide perspective, is it your interpretation that someone will have to, in order to register for a sport, have a birth certificate or go through a medical process in terms of their school system?
I don't know that they would have to do anything additional beyond what's required for registration to request participation in a sport. But I do know that in order to participate in a sport, they will have to go through some level of medical examinations.
So that's the expectation. Okay, I just wanted to kind of find out how you thought that would be handled. I want to look real quick at lines 566 and 567. It says relating to Bill of Rights for foster parents and filing of grievance for violations. I went ahead and looked up that provision of Georgia Code, and it is, so obviously the bill removes the word gender from the Bill of Rights for foster parents and puts in sex. Correct me if I'm, interrupt me if I'm wrong.
Correct.
Okay, so essentially what this part of the code says is, I'll just read it. It's not that long. It says the General Assembly finds that foster parents providing care for children who are in the custody of DHS play an integral, indispensable, and vital role in the state's effort to care for dependent children displaced from their homes. General Assembly further finds that it is in the best interest of Georgia's child welfare system to acknowledge foster parents as an active and participating members of this system and support them through the following Bill of Rights, which is the right not to be discriminated against on the basis of religion, race, color, creed, gender, which would now say sex, marital status, national origin, age, or physical handicap. So is it your understanding that with this change from gender to sex, that transgender Georgians would no longer be permitted to be foster parents?
That's not our interpretation at all.
Okay, so, or would it just be that they could still be foster parents, but now they could be discriminated against for being transgender?
No, that's not the intent. That's not how I interpret the law at all.
Well, that's what it says. I mean, so essentially, if you take out gender and put in sex, then you remove that protection for transgender folks. So even if they would still be permitted to be foster parents, they then come out of the non-discrimination statute.
I don't read it as they are, anyone is excluded from being a foster parent if they meet all the other requirements.
Okay, that's good. We might want to, if the bill is coming to the floor, maybe clean that up a little bit as well, because legally that's exactly what it says right now. And if it doesn't, if you're saying that sex is included includes transgender people, then you're erasing the entire rest of your bill, which is actually what Bostock held, at the U.S. Supreme Court, that sex did include transgender folks, right? Which is the legal rubric that we're kind of under. So I don't know if you, I'm sorry, I'm a lawyer. I don't know if you're a lawyer, so I may be being obnoxious. But essentially, either this provision says transgender people are discriminated against as foster parents under your bill, or you are then subscribing to the U.S. Supreme Court's Bostock definition, which then includes transgender people and all protections related to sex. I'm probably being a little overbroad there, so I'm assuming you're going with the first one.
I'm just waiting for the question, Senator.
That's the question.
Okay.
So I'm assuming you're going with the first one, that is that
the change of the language does not discriminate and does not preclude anyone that meets the requirements for being a foster parent.
Okay. Would you be willing to, if we got that far, work with me on some cleanup language to?
Absolutely.
Okay, great.
Yeah,
thank you. That's great. Okay, I think I just have one more, Mr. Chairman. Thank you for your indulgence on this series of questions. Yeah, in terms of, I do have one on the bathrooms, just operationally. So, say you've got a transgender student, identifying as male student, and that individual, under the legislation, would legally have to use the girls' room, but the person may present as completely male, right? So in that instance, I'm curious your thoughts on, say you've got, a student there, and they're like, this boy just came in and used the restroom, which is forbidden under your bill. So then they actually are wrong, but they don't know that. I mean, they have no idea. How do they know, right? So they go and they tell their mom and dad, and so then the complaint gets filed that, the school has permitted a natal male to use the women's restroom. So will the school then, so then you've got this lawsuit. So since the facts would actually be wrong in that instance, and I would posit to you that this could very easily happen, would the school just then, do you think they'd be able to toss it out, get it tossed pretty quickly on a motion to dismiss by producing the birth certificate or medical records or whatever and saying, no, we actually made the male presenting student use the female? That is exactly how the law works that we wrote. They have to use the female restroom. How do you think that would play out?
Well, so let's just to kind of indulge the hypothetical for a moment. So we're talking about a biological female, correct?
Yes, someone born female,
okay.
Correct. Identified as
Sure.
female birth.
And so the as the bill describes, all of this is specific to athletic teams and sporting events, right? So again, to pursue the hypothetical, in a situation like that, there are things that we know, right? At this point, the kids have been put on the appropriate teams based on their biological sex. The school has designated those specific areas in accordance with the bill, and so all of those things are in place. If in fact, there's a lot of variables in what you're bringing up, but let's just say that the biological female, if they didn't feel comfortable, there's a reasonable accommodation that must be made to allow them access to a single occupancy room. But what you're saying is, what happens if, let's say by accident, I'm assuming is what you're saying, is that a biological female is in a multi-occupancy restroom and a biological male comes in? Is that your question?
No, what I'm saying is, say you've got someone who's this goes into college age too, but let's just go with a high school senior,
sure.
Right? And they are transgender. The individual was assigned female at birth, but the individual has been taking testosterone or other, I don't know the exact mix that you would take, so I don't want to misstate it, but been taking male hormones for a number of years now because they identify as transgender and identify as male. So then they look male. People wouldn't necessarily know that they were female at all. They would think they were male because that's how they look. So then when they show up in the female locker room or restroom, which is what the bill says they have to do, everyone's like, I'm filing a complaint. They let in a boy. But it's based on an erroneous fact pattern because the person is not is transgender. So they look like a man. And that's just gonna I would believe that would cause complaints to be filed that are just factually mistaken. And how is the school gonna deal with those is my question. Because it's really under the bill that they would.
Let's talk about your complaint process, regardless of we get into her specifics. But walk us through the complaint process.
Okay.
That may help.
Yeah.
Does this first go to the?
Yeah. So let's talk about K through 12. All right, because there's actually two layers there. First, there's the Professional Standards Commission that would have the ability to investigate and adjudicate that in terms of anyone that had any kind of responsibility that was in education. So if anyone had an educational license, so the teacher, the coach, the administrator, all those would be adjudicated under the Professional Standards Commission existing process. We did not alter their process whatsoever. It is what it is for that complaints and adjudication. If a student was actually harmed and they could prove harm, then they would have a cause of action against that institution, whether it was their home school for allowing it to happen or for the visiting school that allowed it to happen. That would be the process. So, could it be that there is, a question raised or a complaint proffered? Absolutely. It could be something as simple as,
So in her example, I want to get clarity on this. In her example that she gave you, which essentially somebody is identified, somebody is thought to be female when in fact they are male. I think we understand that. Yeah.
Mm-hmm. Yeah, that's right.
Would that complaint be filed with the Professional Standards Commission, or would that complaint be filed somewhere else?
It would be with the Professional Standards Commission.
Okay. And
but again, this could be something that could be cleared up with a question to the coach. Right? I mean, again, we're chasing this hypothetical. These are, by the time they've gotten to that point, the teams have been set, right? So
that's what I'm getting to.
Yeah.
I'm thinking about player cards, even in club level, athletics for 8-year-olds. You have player cards where the birth certificate's been checked for a date. They have that. I believe your bill has a birth certificate is that primary evidence, and is that conclusive evidence under your bill, or how do you?
No, it is a means to determine eligibility.
Okay.
Provided it's in accordance with the, that it's got to be designated close to the actual date. That way you're not dealing with issues where a state may allow someone to alter their birth certificate.
Okay, so I hear you saying a couple different things. One, under the scenario that Senator Parent laid out, you think that perhaps that would be a coach-to-coach conversation, player card, roster, or something might be produced that would clarify that. But if it does go to the Professional Standards Commission, and a birth certificate was produced, would that then, to her question, would that then be dismissed as a claim? Obviously you can't speak to what they would do, but help me understand what your bill does as it relates to birth certificate, or then kind of what I understand you saying is a kind of other evidence.
Well, so it establishes the birth certificate as a means to determine eligibility. It doesn't prevent, however, a school or a university from requiring and relying on, medical evidence through, again, everybody that participates in a sport has to have some level of medical scrutiny in order to make sure that they, can play and not get hurt. So it's a liability issue. But yeah, I would just say functionally in this hypothetical, I would see just, a coach-to-coach conversation regarding this, and if that was not satisfactory, then anybody could make that complaint to the PSC, and they would do their investigation. In my conversations with the PSC, they investigate every complaint that's put forward to them. So I would certainly expect them to do the same in this regard.
What's the path for the private right of action that's in your bill? Is that only after? Is that essentially a secondary remedy, or can that be going in parallel?
It could be going in parallel,
okay.
because it really is a separate issue, because the PSC could be investigating a particular an incident related to an individual that they have purview over, versus a cause of action could be against the school as a whole, the school system as a whole, the university, or whatever it was. So those two things could actually be going in parallel.
Does that help clarify for you, Senator?
A little bit, and if I can ask just one
You
more,
can
and I
follow
know
up, sure.
Senator Hatchett
Give you
may
one
have
more,
some-
and then we'll see.
have some
Yeah,
questions
what
as well. So, thinking back to my high school, we utilized the same spaces during the day, right? And, for PE and restroom use and what have you, that we also utilized after school if there was an athletic event. So, tell me, is the bill only applicable when there's like athletic events, or is it during the day students also need to adhere to what's in the bill, or are we not getting into, in your legislation, usage of bathrooms for just like everyday students that aren't on sports teams?
Right. Everything in the bill is specific to athletic events.
Thank you.
Senator Hatchett, did you have any questions? Okay. What we'll now do is, that leaves us a good chunk of time, 30 minutes. Well, let's do 20 minutes of public testimony. And just looking at this, there are far more people that are opposed to the bill than in favor. So here's what I'm going to do with the 20 minutes. I'm going to allocate 16 minutes for those opposed and 4 minutes for those in favor, because there's only 2 of you that are here in favor. So it gives you 2 minutes each. And then we will go down the list, and we'll do this similar to the way that Chairman Strickland does in Judiciary, which I think works pretty well, is we'll run the clock. And if you're speaking, it means somebody else is not. So that let you guys manage that how you wish. So we will start with those in favor of the bill. I will give you guys 4 minutes. The first person to speak in favor is Mike Griffin.
Thank you, Mr. Chairman. I am Mike Griffin. I'm the Public Affairs Representative with the Georgia Baptist Mission Board. I don't know that Mac Parnell is going to be here to testify, so they gave me 2 more minutes. I don't know. But anyway, I don't need extra time, really. But anyway, we are in favor of this legislation. We appreciate Representative Josh Bonner, and we do support HB 267. And Georgia Baptist have passed a resolution entitled Protecting Girls Sports. We did that in 2021. Georgia Baptist represent up to 1.4 million Georgians and up to 3,500 churches. And so we were very strong in our support for this kind of legislation. And we support this bill from basically 3 very quick perspectives. First of all, as Georgia Baptist, it would be a biblical perspective related to the fact that Genesis 1:27 says that God created either male or female in his image, and everyone is to be loved and appreciated, and they are uniquely special and created by God. Secondly, a common sense perspective. We think that it just makes common sense that biological males should compete against biological males and vice versa. Just the very nature of who we are at birth puts us naturally into one of 2 genders. And even 400 years from now, if we're removed from the grave, our DNA is going to be the same as it was at birth. And then thirdly, from a fairness perspective, it's simply not fair for girls to be forced to compete against those that they are physically are not equal to. It is a fact that men naturally have greater muscle mass, bone density, higher lung capacity, larger hearts than women. It's also not fair that girls be discriminated against by being denied college scholarships and recognition for holding sporting event records because biological males are allowed to compete against them. We would deeply appreciate this committee's favorable support for this very important and needed legislation. Thank you, Mr. Chairman.
Thank you, Mike. Any questions? Actually, we're not going to do questions from the committee. Is there anyone else here to speak in favor? All right, I'm going to give that time to those speaking in opposition, so we will give you guys 18 minutes. And I believe there's 2 sheets here. So Sarah, were you the first one to sign up as far as you know? Okay. So I'm going to start from this first sheet. So first up, when you do come to the podium, please just identify yourself and who you're with, and you can take as much time as you want, but at the end of 18 minutes, we're going to move on. So Sarah Hunt Blackwell, you're up first.
Good evening, Chairman and members of the committee. My name is Sarah Hunt Blackwell. I'm the First Amendment Policy Advocate with the ACLU of Georgia. I'm here in opposition to HB 267. We oppose the first 3 sections of this bill because of their potential for discrimination against trans youth. And beyond that, we have additional concerns about sections 4 and 5 because of the range of Georgia code that is implicated. First, nothing in the first 3 sections of HB 267 actually protects student athletes from any real harm. The bill does nothing but perpetuate fear-mongering and scapegoating of trans and intersex people. To be clear, this bill is not really about unfair advantages in sports either. This is exemplified by the fact that 1, the restrictions apply to sports and other, quote, interscholastic competition that require no physical contact. And 2, the restrictions apply regardless of team size. Next, our concern with Section 4 is that by replacing the word gender with the word sex throughout Georgia code and limiting sex to either male or female, there will be thousands of people in Georgia who would become wholly unprotected by state law, namely trans and intersex people. Coupling that with the numerous provisions of Section 5, HB 267 ultimately excludes trans, intersex, and non-binary people from receiving state services and protections. That is the exact opposite of what this body is here to do, and is an unfathomable affront to the rights of trans, intersex, and non-binary Georgians. Privacy rights of trans, intersex, and non-binary Georgians would also suffer under HB 267. The fact that someone's sex assigned at birth differs from their current gender identification may be completely unknown to that person's friends, coworkers, and other people in their life. This bill's requirement for everyone in Georgia to be recognized as either male or female forcefully exposes or outs people who may not want the private nature of their assigned sex to be disclosed to anyone else. There are myriad issues with HB 267, as well as a similar bill introduced in the Senate, SB 1. This bill invites discrimination, privacy infringements, and in essence, the erasure of entire populations of people in Georgia. With all due respect, it should not be the focus of this body to determine which sex or gender people are required to be recognized as in order to receive the full protection of the laws in the state in which they live and pay taxes. We ask that this body instead focus on protecting all Georgians, even those whose gender identities you may not agree with. Please vote no on HB 267 once it reaches full committee. Thank you.
Thank you. Next up is Noel Heatherland, and then Dr. Jason Schneider, you'll be on deck.
Hello, my name is Noelle Heatherland. I work for Georgia Equality. I'm showing up in support of protecting all girls and women from the harmful consequences of this bill. All of us agree that we care about keeping women and girls safe. What we don't always agree on is who gets to count as a woman or a girl. I have begged in prior testimonies for everyone here to see and care about the human rights of transgender Georgians, and it seems some people only care about some Georgians' safety. But if that is indeed your goal, voting for HB 267 is misguided, even for that purpose. The language in this bill surrounding reproductive systems to make a definition of sex is highly worrisome and creates opportunities for invasive inspections and trauma for all young people, including girls who are not transgender. This bill, while claiming to be about sports, is actually a much broader piece of legislation that will lead to troubling unintended consequences. The bill author himself doesn't even seem clear on all of the far-reaching ways this could impact any girl or woman, including those who are not trans. First and foremost, this bill is obviously intended to hurt transgender people, but other people will also be negatively impacted. Women and girls should not be afraid of being called out for being too good at their sport. In Utah, a high school girl had to be placed under police protection after being falsely accused of being trans because she excelled in sports. Serena Williams, one of the most dominant athletes in history, has faced racist and misogynistic scrutiny over her physique, with critics questioning whether she was too strong to be a woman. I think about my own self as a little girl. As you can see, I'm almost 5'9" without heels, and I've been this height since around age 12. I was a good 6 inches to a foot taller than most other girls when I was a preteen. Would I have been targeted under HB 267? All people, including non-transgender people, are born with various advantages that help them in sports. It's a slippery slope to make decisions about who someone is based on stereotypes or how they look. The bill author also said the school is free to inspect if they choose. As a child sexual abuse survivor, that frightens me beyond description. It must be hard to compete with all your heart and lose at times, or to share a trophy momentarily with someone you dislike or disagree with. And as my African American partner reminded me, we saw similar complaints and outcries when society, including athletics, was desegregated. If the few transgender women who do compete at a collegiate level truly were so overly advantaged, wouldn't they win all the time rather than on occasion? Also, I'm not sure if you all heard about what happened to a black cisgender woman in Arizona. She was accosted by 2 male police officers in a woman's restroom because someone suspected she was a male. She was not. Can you imagine how traumatizing that was? Do all women and girls need to start carrying a birth certificate around everywhere they go? I'm a lifelong Georgian and a graduate of the University of Georgia. If you really cared about leveling the sports playing field, you would deal with equalizing girls' and boys' coaches' pay and ensuring that girls have the same access to quality equipment and field time. If this bill is going to pass, if you are going to say that all of this falls under one legislative action, let's propose a more honest title. HB 267 is the erasure of Transgender Georgians Act. I urge you to vote against this bill.
Thank you, Noel. Next up is Dr. Jason Schneider, and then Jeff Graham, you are on deck. Hello.
Good evening. Thank you, Mr. Chair, members of the subcommittee. Jason Schneider. I'm a local physician that cares for a wide range of people, including trans and gender diverse people. So why am I up here as a physician offering testimony against HB 267? Well, engaging in sports is about more than competition and winning. It's about physical and mental health and belonging. Participating in sports is linked to better outcomes in academics, self-esteem, confidence, stress, and anxiety. As previous questions and testimony has indicated, this bill has an unnecessarily broad overreach in many ways, but also applying to youth of all grades, K through 12 and college. Because according to experts from the American College of Sports Medicine and their consensus statement, before puberty, sex differences in athletic performance are minimal. So the approach proposed by this bill is scientifically invalid and just not necessary. Additionally, this same group is currently finalizing a paper on the inclusion of trans athletes in sport, so let's let the experts do their job. But going back to the broad overreach of this bill, because the bill proposes to narrowly redefine sex based solely on one's sex at birth, it could have many unintended consequences on the state legal code, as has been highlighted. I know that only 10 to 15% of what I do for my patients has to do with what goes on between me and them in the exam room or in the hospital. And I'm bringing up the concept of social determinants of health and the impact of violence, employment, and public accommodations. This bill, as it's currently worded, could be used to bar trans women in Georgia from life-saving domestic violence shelters and rape crisis shelters, lines 317 to 322. It could impede trans Georgians from gaining employment, lines 508 to 509. It declares that transgender Georgians will be listed incorrectly in pharmacies' patient records systems, lines 517 through 18 and line 530. It also introduces language that could be used to ban transgender people from using restrooms without clear guidance or consideration of the facts, or even delineating between public and private accommodations, highlighting lines 317 to 322. And although gender was put back under hate crimes protections in Section 5.2 of this bill, law enforcement agencies here in Georgia may interpret Section 5-1B's erasure of transgender people in data collection to mean that reports of crimes will not recognize trans Georgians as falling under those protections. Call your attention to lines 323 to 327. It's important to note that, according to a recent study, transgender people are over 4 times more likely to experience violent victimization, including rape, sexual assault, and aggravated or simple assault. This bill and its broad overreach would remove many added legal protections for this already vulnerable population of Georgians. As a Georgia physician that cares about the health and well-being of my patients and all the people in this state, I urge you to vote no on advancing HB 267.
Thank you, Doctor. Next up is Jeff Graham, and then I believe L. Knott is next.
Mr. Chair, my concerns about sections 4 and 5 have been addressed by other speakers.
That's very generous of you to give your time to someone else. Elle, you will be up next, and then Marissa Pyle, you will be on deck.
Good evening, members of the committee. Thank you for your time. My name is Elle Knott, and I'm the Advocacy Manager at YWCA Greater Atlanta, a women's organization where we are on a mission to eliminate racism, empower women, and promote peace, justice, freedom, and dignity for all people. We oppose this legislation because it does not empower women or promote freedom and dignity for all people. HB 267 does not protect women's sports. If it were intended to do that, this bill would address pay equity for coaches of female teams or systemic disparities in resource allocation and funding, but it doesn't. What this bill does do is undermine the rights of transgender individuals, youth, really, a community that already faces disproportionate levels of discrimination, violence, and exclusion. This bill sends a harmful message that transgender youth do not belong, creating an environment that fosters bullying and mental health struggles. At YWCA Greater Atlanta, we support all women and girls, including transgender women, and we recognize that their inclusion in sports is about dignity, equality, and opportunity. Bathroom and sports restrictions lead to abuse and harassment for trans youth and can invite discrimination against girls, requiring them to prove their gender if someone thinks that they're too skilled or too strong. I am no athlete, but I do know that one of the core tenets of athletics for students is learning about how to win and lose well. I know that losing isn't fun, and in a competitive environment, I fear that athletes may use this ban to bully or single out cisgender girls who may be particularly tall or muscular, the exact opposite body type of myself. I'm afraid that this bill could lead to misgendering of girls who are perceived to be too strong for their competitors. These restrictions will be almost impossible to enforce and dangerous to women. I'm grateful for the amendment related to preventing visual checks on line 264, but I wish it went a little further and also prohibited physical checks. Maybe that is an amendment that you all will consider if you won't considering just voting no on this piece of legislation. Lastly, but very importantly, I want to address the codification of the definition of sex within this bill. It's obviously erasure of transgender identities, but it's also more than that. Codifying sex in such a rigid manner disregards the complexities of the human body and biology. Women are more than our reproductive systems, and defining sex in Georgia's code based on our chromosomal or reproductive capacity is incredibly limiting. It could lead to discrimination against postmenopausal women, women with fertility challenges, women who have had hysterectomies or other medical procedures. YWCA Greater Atlanta stands firmly against any legislation that marginalizes vulnerable communities under the guise of protecting women's rights. Georgian women need our lawmakers to focus on issues that would actually improve their lives and keep them safe. Please do not advance this bill out of the subcommittee. Thank you for your time.
Thank you. All right, next up is Marissa Pyle, and then Carrie Scott. You will be on deck.
Hi, Senators. My name is Marissa Pyle. I'm here in my individual capacity, and I am a living, thriving, loving, today slightly irritated and hungry, non-binary person. I have been that way, that same person, every day of my life. When I knew my then Democratic Lumpkin County Commissioner, Steve Gooch, as a toddler, I was my full self. When I played volleyball, when I ran track, practiced karaoke, did karate, I was a non-binary person. When I now run my perfectly very average runs, some might even say below average, crossing perfectly average finish lines, I am not something that goes bump in the night. I am the same person who found friends, leadership, and community on those sports teams where I learned to stand up to bullies, not elect them. I remain that person now. I want to say clearly that to queer questioning and kids who are watching this committee feeling excluded, that what this body says does not matter. Nothing in this building will ever determine your humanity and your deservingness to be who you are. I work in this legislature every year, and I bring my entire queer self to this building because the world needs all of us and all of you. To those who come here and bare your souls for the hope of doing good, I love you, you are heroes, and this work is hard. To the committee, pretty much likely nothing we say here will change your votes. Let's be honest with ourselves. No amount of queer people, no amount of desperate parents begging for their lives and for their families, no amount of medical experts contradicting every sad, skewed, and false justification for this legislation will move you. The truth is that the Republicans in this body have made a political calculation that trying to legally exterminate trans people in the eye of the state is the move to buy you one more cycle of political power. The hate groups that have written this bill have acted accordingly, and we find ourselves here, point A to point B, with some mediocre swimmers trailing and riding the wake behind us like transphobic dolphins. One thing that I will say to the majority on this committee is that if anyone you love ever comes to you and shares their truth that they are gay or trans or they're just not sure yet or somewhere in between, I hope to God that you are hypocrites. That you go back on what you are about to vote to do, that you love and accept them despite what you are about to do today. The final and only thing that I assure you of is that you will fail, just like you have every single other time you make this devil's bargain. No matter what you do, we will always be here. We have always been here, we have been here before, and we will be here after. All that you are doing is ensuring that more of your neighbors, more of your community members, more of your own colleagues' children get hurt in this process. Does that make you bad people? I leave that between you and your own thoughts.
Thank you. Next up is Carrie Scott, and then Brooke Mills, you'll be on deck. That may put us at overtime, actually.
Hi, my name is Carrie Scott. I'm here on my own behalf. I just want to point out that this bill is not well thought out from top to bottom. In particular, listening to the sponsor talk about the complaint process, the language of the bill says that there will be a cause of action with no requirement that it go through the PSC first if a student encounters any member. So it could be a parent, it could be a coach, it could be a member of the public. And so this explanation was factually incorrect of what the bill says. It also says in line 306 that in terms of sex and gender, it says, with respect to sex, the term equal does not mean same or identical. This bill writes in separate but equal into the Georgia Code for matters of sex. If a public school says that only boys are allowed to take science classes and only girls are allowed to take home ec, then wouldn't that be sanctioned by this bill? And it goes much farther with this laundry list of other changes. What about driver's licenses? The driver's license is meant to as an identification document. Will I have to have my license changed from female to male under these definitions of sex? How does that help anyone identify me? And if that's the purpose of this bill, then I think that the sponsors should be upfront about it, because I think that other people would have a lot of opinions on that beyond the sports debate. So I beg you to not support this bill. It goes way farther than SB 1 and way farther than is necessary. It is cruel. Thank you very much.
Thank you. And we're at time, but we'll go ahead and have Brooke come up.
Good afternoon. It is great to see that most of my list has been crossed off by other people before me, but I still need to address, unfortunately, a number of lines and case laws that this bill fails against, especially within the 11th Circuit. Now, let's just go through this line by line. Lines 46 through 48, and the definition set, and also lines 147 through 149, 226 through 228, 303 through 305. The sex verification based on observation at birth goes against the current jurisprudence and law in Georgia that recognizes a bearing standard for recognition of sex change, and that has been upheld by the 11th Circuit in Corbett v. Taylor, 2024. The sex definitions fail under the standard set in Washington v. Trump, 2025, last month. Pretty recent. As it says in Washington v. Trump, sex-based classifications are subject to heightened scrutiny. Hecox v. Little, but in line, hold for it. I am so sorry. I appear to have misplaced the line here. I have way too many notes. So let's so going on to the inaccurate new sex-based definitions that under within Georgia there are approximately 178,000 intersex Georgians that do not fit under the DSD mechanism presented within this bill due to mosaicism and chimerism. Just within my own social circle, I'm friends with an intersex woman with mosaic chimerism with both sets of XX and XY chromosomes and both sets of reproductive capabilities. Yet under the definitions set by this bill, set at birth, she would be classified as a male despite the fact that she is capable of carrying a child to term. Of course, separate but equal was covered. Now, the statewide bathroom one, I don't feel has been touched on well enough with lines 317 through 322, because despite the right of action largely being relegated to the PSC in lines 279 through 282 with the right of action, it doesn't clearly confine that. Especially when it mentions injunctive relief, compensatory damages, and attorney's fees, which would indicate litigation. So, for instance, under this bill, if I were to use either sex segregated bathroom, would that mean I could have a case brought against me by someone in the building because they object to my androgynous appearance or my not so easily identified state of being? And of course, the driver's license was brought up with sections 5.4 and 5.6. With that, are we talking about revoking the estimated 12,000 transgender Georgians' driver's license for those who meet the definitions for standards of sex change within the OCGA? Are we talking about revoking 12,000 Georgians' birth certificates? And, of course, my favorite line, 531. Are we talking about revoking transgender Georgians of their fishing licenses? That one just stand out to me a little funny. And let's see, already covered Corbett, covered Washington. One more bit of jurisprudence for the 11th Circuit in regards to bathrooms in schools. Doe v. Alabama, 2024. Adam v. St. John City, 2022. And a notable case in Georgia for Bostock v. Clayton County, 2020. And based on the new sex definitions, this would put Georgia out of compliance with the Real ID Act federally. Now, because of the code sections... I'm going to have you
wrap it up, okay? I'll give you another 30 seconds. You're good. Go ahead.
All right.
Finish your
And based on the new sex definitions used in the code revisions, this would cause issues for GDOC where trans women and trans men would be put in prison arrangements. That would be a violation of the current judgment against Georgia and Diamond v. Owens. I feel weird saying this, but with SB 1, at least in terms of jurisprudence, you got it pretty well for the 11th Circuit. You got it pretty well with Senate Bill 1 in terms of jurisprudence. This is not an endorsement of it, but you got it pretty well with Senate Bill 1. HB 267 is a judicial and litigative nightmare, and that's before you even get into the ethics of it. Thank you.
Thank you. All right. Thank you for everyone that took the time to be here, and for those of you that we did not get to, I apologize, but we got to more than half of the people that signed up to speak. So I'm going to ask Representative Bonner to come back forward, and I'll give you the floor to respond, and then I'll open the floor to committee questions. Didn't know it was ever there. The floor is yours, sir.
Well, thank you, Mr. Chairman. Thank you to the committee. I will say that these, number one, I do appreciate all the thoughts expressed by both sides. It's certainly an issue that does generate a lot of emotion, a lot of conversation, those kind of things. I will say that in all of this, I like to focus in on not who's perceived to be excluded, but who the bill is protecting, and that's female athletes in Georgia. So I'm the father of two daughters, one that plays soccer, and I do not want, and I don't think our constituents, and I don't think that the majority of Georgians want to be in a situation to tell their daughter that no matter how hard she trains, no matter how much she sacrifices, no matter how much effort she puts into being the absolute best soccer player she can be, that if the moment she steps on that field, she will be at a decided disadvantage because she would have to play against a biological male. Furthermore, I do not want to put any girl in Georgia in a situation where they would be exposed to a biological male in an area that they're changing. I just don't think that that is in line with my constituents' values, and I don't think it's in line with the majority of Georgians' values either. So that, Mr. Chairman, is where I would like to focus. I think the bill does just that. Again, it is filled with, I think, accommodations throughout, whether it's in teams being designated as male, female, or co-ed, or changing areas being designated as male and female with a reasonable accommodation being made. So I don't think the focus here is on anyone that's excluded. I think the focus should be right where it ought to be and is the intent of this bill, and that's to protect female athletes in Georgia.
Thank you, Representative. Any questions from the committee? Senator Perrin.
Thank you, Representative. I appreciate your coming back up, and I appreciate your intention with the bill for it to be about sports, but you would acknowledge, I assume, that by changing gender out for sex in many places, 40 plus, I think, without in the code, it goes far beyond, interscholastic or post-secondary sports. Would you not?
Well, I think it does. For instance, on that issue, it's important that we have accurate data, which I would assume you would agree with that, correct? That it's important to know when we bring in statistics that we have accurate data. And the reality is that by having the word gender in our code as it is now, it does not provide an opportunity for accurate data. Because I would ask you, for instance, how many genders do you think that there are?
Well, what I would ask you, because it's my turn to ask questions, is part A, wouldn't you agree that the data is not accurate because it makes no ability to accurately reflect up to 2% of the population that are intersex?
So I think that, again, ultimately those that fall into that category are at some point assigned a sex or they adhere to a sex. But again, you're talking about a very minute statistical data point in that. But I think in general, it is incumbent upon us as a state to be accurate. And by defining sex and collecting data in terms of that is the most accurate way to do it.
Well, thank you for that. I would say that one of the things with intersex people is that it can actually change, right? Because you hit puberty, and then that is one point when you may learn things that you did not realize before vis-a-vis your intersex status. So that it is an issue. And in terms of accuracy, again, I would suggest to you that your bill is undermining that by putting into place what is actually eliminating biological reality. What you're telling me is you're wanting to adhere to biological reality. But what I'm telling you is your bill does not do that because it makes no provision in Georgia law for folks who are intersex or transgender.
The intent is to collect accurate data. We define sex as either male or female. We believe that those are the appropriate data points to move forward in Georgia code.
So let me just
in place of the word gender, which again I would just put out there, and to anyone, tell me how many genders there are.
So let me just follow up. Yeah, I got just one more. I know we're
Okay.
out of time. Thank you, Mr.
I was going to
Chairman.
give you one more, so that works.
Okay, great. So I've been talking about intersex folks, but I want to just ask a final question about transgender folks. So is it your position? And we're I know you prefaced your closing remarks talking about the sports, but as you know, I'm sure you've heard plenty of times in the last few months, the biggest issues with this legislation are really related to its sweeping nature in terms of Georgia code and the sort of elimination of the possibility of, well, first of all, being intersex, but also of being transgender. And so I guess my question is it your position, because you said, we're going forward with male and female, is it your position that transgender people don't exist?
No, the bill makes no distinction in that regard. Everyone exists. Nobody is denying the existence of anyone. We're simply saying that biological males should not compete against biological females.
Well, but
but there does create. Again, there's a co-ed, there's reasonable accommodation, so it doesn't. I don't see how in any way that the bill denies the existence of anyone.
Well, I'm just going back to all the other parts of the bill that don't deal with sports, right? So anyway, I know I'm wrapping up here, but I would just suggest you consider that when you've made essentially the existence of two, actually it's three, I guess if you include non-binary, pretty substantial, small but substantial, and categories of people, a legal impossibility, that does cause questions. It's like, well, to you, then what are they? Like, what's your?
I don't
you're
understand
just
your
you're
question.
saying. I guess you're saying. So, say someone, as one of our speakers went forward a few minutes ago, they're an adult. They are transgender. They have transitioned. They have all their documents say their gender identity, no longer say they were assigned the other gender or sex at birth, but now they've transitioned. They've had a sex change operation. So I guess your position is no, that's just, none of that's relevant.
None of those things have anything to do with this bill.
But the things they do, because you're doing everything.
Well, they don't. You said they're an adult. So if they're outside of a post-secondary institution and they're adult, they can do whatever they want, right? The bill makes no distinction on that. This is specifically in regards to K through 12 in our post-secondary institution. So.
So I've got one question, then Senator Hatch, I don't know if you do or not, but somebody made a quick comment that I'd like you to opine on, that your description of the complaint process was inaccurate. Did you catch that? And did you follow?
I
didn't hear.
I did catch that, and and I don't believe that to be the case. In fact, we worked extensively with the Professional Standards Commission in their input and actually put in the bill what they recommended. So I certainly don't think that it's incorrect in that sense. There is a procedure for complaints through that venue. The cause of action is certainly, there's a legal process for that, but again, there's also a legal standard that goes along with that. So at the same time, you got to prove that there was some kind of harm that was caused in order to move forward with that. So I certainly disagree with those comments, but I think it is pretty clear in the bill, and it's in accordance with input from that very organization.
got one last question. There have been instances of a female kicker on a men's football team. There have been instances of a female golfer that goes and plays on the men's golf team. And I know that part of what Title IX talks about is not necessarily you need to have equal teams. In other words, you don't need to have a female football team, but you need to provide alternative sports such that the head count is congruent. Can you just speak to, I don't know what your bill does in that regard, if it does anything at all.
It doesn't prohibit those two instances that you talked about. In fact, it does allow for male and female teams to practice together, or a male to practice on a female team. It just protects their scholarships and their roster spots. But it wouldn't the female roster spots. It wouldn't preclude a female kicker from being on a male football team.
Okay, thank you. Senator Hatchett, do you have any questions?
Just maybe one, Mr. Chairman. I know there was a lot of talk about Leah Thomas when we had a similar bill going through the Senate. And I was a swimmer myself. I swam at Georgia Tech. I know Georgia Tech got a lot of focus because that's where the NCAA championship was held that year. At the time, Georgia Tech was had to bend to the will and the rules of the NCAA. The NCAA, my understanding, will defer to the rules of the governing body or the state in which a competition is being held. With this law in place, if a similar situation were to occur at, let's say, the NCAA swimming championships at Georgia Tech, would Georgia Tech at that point be able to intervene and prevent someone who clearly has a competitive advantage from competing?
Yes.
I think that's all I got.
Okay, thank you, Senator. I have been in communication with Chairman Strickland. We're not necessarily going to take action today since there's only 2 members of the committee and a chairman. I would open the floor, though, to any discussion. If anybody would like to have anything other than a question, so we can have a discussion time, or if you both feel like you have said what you'd like to say, then we can adjourn this committee. And I know that Chairman Strickland has been watching, and I will provide a report to him based on that. Do you want to press your button?
I know we've got 2 bills, Senate Bill 1 and we've got this bill. Both seem to be similar, but I know there are differences. I don't know if Ledge Council or if someone has already created this. I'd love to know the differences between the 2 bills so that we could compare and if necessary combine or whatever needs to be done between this and Senate Bill 1. So I can get with Chairman Strickland, or I wanted to ask, do you have any document like that would compare the 2?
I haven't seen a comparison. I don't know if you've seen one or produced one, or if you want to highlight anything that you know are the substantive differences between the 2 bills. But I have not seen anything from the Ledge Council. Would certainly be happy to ask for that.
Yeah, I mean, just the ones I think kind of off the top of my head, I know the PSC is certainly one, and then the code revision is another. I think that is 2 differences in that. A number of the definitions are consistent throughout both bills. I think there are a few that may differ slightly, but I would say there's a lot more alike than there is different.
Okay. Thank you.
I would agree with that. Senator Parent, any comments? We good? All right. With that, we will adjourn the committee. Before we do that, I would like to thank the 2 of you for coming, because it would have been difficult if it's just myself. And to the members of the public that came to speak as well, I appreciate you guys being here. Representative Bonner, thank you for being here. I will produce a report of this subcommittee for Chairman Strickland, and then it will be in his hands kind of how to proceed from there. So thank you all.
Thank you.
Everybody have a good night. Thanks.